It's an honor to be here with Steve Halbrook. I could easily spend all of my allotted time describing Steve's contributions to the revival of serious interest in the Second Amendment and giving him the praise he deserves. But I've been asked to focus on the Supreme Court's emerging jurisprudence, so I'll just begin with a couple of brief remarks about the significance of his work. When Steve first began his research more than 30 years ago, he had some handicaps that eventually turned out to be advantages. First, he was a practicing lawyer rather than a legal academic. Second, he thought that the Constitution means what the people who created it thought it meant. Now, these were they might not sound the handicaps to you, but they were handicaps because the court at that time had very little interest in the original meaning of the Constitution, and the legal academy had virtually no interest in what outsiders like Steve might have to say. On top of that, the courts and the professors universally thought that the Second Amendment was a kind of bad joke. Well, they're not laughing anymore. Eventually, Steve is going to get the credit he deserves for this remarkable reorientation of legal thought. Now, tonight I'm going to talk a little about the progress that's been made and about its limits. 2 years ago, as you know, the Supreme Court struck down Washington, D.C.'s handgun ban in the Heller decision. As Alex mentioned, this was the first time in history that the court has found any law in violation of the Second Amendment. Apart from its significance for the politically contentious issue of gun control, Heller was an important test case for the interpretive theory of originalism. There were virtually no relevant Supreme Court precedents, and certainly none that could be considered dispositive. Heller was also a good test case for originalism because the Second Amendment poses some genuine puzzles. Its text, for example, uniquely combines an explanatory phrase and a command. It says, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." Now, what does that preambular reference to the importance of a well-regulated militia have to do with the right of the people to keep and bear arms? One usually thinks of constitutional rights as obstacles, not spurs to regulation, and it's not immediately evident, at least to typical 21st century readers, how this right to arms could contribute to the establishment or preservation of a well-regulated militia. A different kind of puzzle arises from changes in the circumstances to which the constitutional provision must be applied. American society is dramatically different from the world in which the Second Amendment was adopted. The militia organizations extolled by the founding generation have withered away, and advances in the technology of weaponry have produced arms that are far more dangerous than those available in the founding era. That raises a question. Is it even possible, let alone prudent, to apply the Second Amendment's command to a modern society in which it could have radically different effects than what would have been expected in 1791? Now, Heller was a good test case for another reason. The opinion was assigned to the court's leading exponent of originalist jurisprudence, Antonin Scalia. Scalia makes a powerful case, based in large part on Steve Halbrook's work, for two important propositions. First, the right to keep and bear arms is an individual, private right, not a right of the states to organize militias. Second, the purpose of the right is to enable individuals to exercise their inherent right of self-defense, including the right to defend themselves against criminal violence. But that's not enough to resolve the initial textual puzzle about the relationship between the prefatory language and the operative clause. Scalia tries to do this by claiming that the right to arms was a pre-existing right and that the preface of the Second Amendment merely tells us why it was codified without changing the content of the pre-existing right. Now, there are two main problems with Scalia's analysis. First, he says that the constitutional text itself, which refers to the right to keep and bear arms, implies a reference to a pre-existing right. But that's a linguistic fallacy. You could write a law saying that the right to free medical care at government expense shall not be infringed. That would not imply that the right already existed. Of course, there was a pre-existing right to arms, and the Second Amendment could be referring to that right. But then you would have to try to figure out the scope of the right. In practice, the pre-existing right was almost unlimited because there were almost no laws restricting the right in America at that time, and none from the federal government at all. That's clearly not what Scalia means, because he later endorses a great many restrictions that did not exist in 1791. Alternatively, you might try to figure out what kinds of restrictions would have been acceptable if legislatures had wanted to impose them. But there was almost no discussion of such questions in the founding period because there was no reason for anybody to have such discussions. Now, the second big problem with Scalia's effort to deal with the prefatory language involves his claim that it merely explains why the pre-existing right was codified. His explanation of the purpose of the codification makes no sense. Scalia asserts, and here I'm quoting, that the Second Amendment's prefatory clause announces the purpose for which the right was codified, to prevent elimination of the militia. Now, what he says here is just false. The text of the Second Amendment refers to a well-regulated militia, not to the militia. They are not synonymous terms, and Scalia himself acknowledges as much when he distinguishes between an organized and an unorganized militia. Building on his fallacious premise, Scalia claims that the Constitution assumes that the militia is already in existence and that it means all able-bodied men. Now, that's not exactly wrong, but it makes nonsense of Scalia's claim that the purpose of codifying the right to arms was to prevent the elimination of the militia. The nation's able-bodied men, which is what Scalia says the militia is, would not be eliminated if they or anyone else were to be disarmed. Scalia's argument also carries the fallacious implication that Second Amendment rights are limited to able-bodied men, which they're not. The most difficult textual question, which Scalia never even addresses, is how codifying the right to arms could have been expected to preserve, promote, or prevent the elimination of a well-regulated militia. Now, I believe there's a perfectly good answer to that question, but no answer of any kind will be found in Scalia's opinion. That is a very, very serious shortcoming in a judicial opinion that purports to rely as heavily as Scalia's does on textual analysis and originalist interpretive principles. Scalia's failure to identify any textual or historical evidence about the scope of the Second Amendment right has spectacular effects when he addresses the principal question at stake in the Heller case itself, namely, whether the D.C. handgun ban was unconstitutional. The court concludes that it is unconstitutional, but the only reasons that Scalia offers are that handguns are popular weapons for self-defense among Americans today, and that he thinks there are good reasons why handguns are popular. That is not an historical or originalist argument. If it's any kind of argument at all, it's probably a disguised and incomplete form of the quasi-legislative interest balancing approach that Scalia disdainfully dismisses elsewhere in his opinion. It's very striking that Scalia abandons any pretense of originalism when he addresses the issue actually presented in the case. What's even more striking is that he also includes a series of astounding and unnecessary comments endorsing various forms of gun control that were not at issue in the case. First, he says that nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill. I guess that sounds reasonable, at least at first, but how long-standing have these prohibitions been? Scalia either doesn't know or he decided not to tell us. Apparently, however, the first general ban on the possession of firearms by felons was enacted in 1968. That's right, 1968. Long-standing? That was 177 years after the adoption of the Second Amendment and less than a decade before the D.C. handgun ban was adopted. Aside from the absence of historical support involving the pre-existing right to arms, the conclusion is inconsistent with what Scalia himself calls the core of the right. namely self-defense. On what understanding of that core right does it make any sense at all to leave American citizens defenseless in their own homes for the rest of their lives on the basis of nothing more than a nonviolent felony like tax evasion or insider trading? It would make more sense to say that these felons can be silenced for the rest of their lives. Regulatory crimes, after all, usually involve an abuse of speech, such as making false statements to the government or negotiating contracts that the government doesn't like. But they don't have anything at all to do with firearms or violence. Next, Scalia endorses prohibitions on the carrying of firearms in sensitive places such as schools and government buildings. Scalia provides no evidence that Americans were forbidden to carry firearms in schools and government buildings prior to 1791, nor does he explain what makes these places sensitive or how courts are supposed to go about determining the scope of this newly announced exception to the right to arms. Is a university campus more sensitive than a shopping mall across the street? Is a government-owned cabin in a national forest more sensitive than a privately owned hotel? Did the whole city of New Orleans become a sensitive place after Hurricane Katrina, thus justifying the government in forcibly disarming law-abiding citizens whom the government was unable to protect from roving bands of criminals? We are never told what limits, if any, there are on the discretion of courts to decide that certain places are so sensitive that Americans may be disarmed when they go there. And we're certainly not given any historical evidence to support such discretion. The Heller majority next endorses laws imposing conditions and qualifications on the commercial sale of arms. Once again, Scalia presents no historical evidence about the nature or even existence of pre-1791 commercial regulations, nor does he suggest any limit on government's power to impose conditions and qualifications on these commercial transactions. For all we're told here, Congress could place a prohibitively high tax on the sale of firearms or create burdensome regulatory obstacles that would make it impractical for a commercial market to exist. If the court means that it would improve only reasonable conditions and qualifications, it failed to say so, and it suggested no criteria based in history or anything else by which reasonable restrictions could be distinguished from unreasonable restrictions. The court also endorses bans on the concealed carry of firearms. Once again, Scalia provides no evidence that such bans existed prior to 1791 and no evidence that anyone thought they would be permissible. Instead, he vaguely relies on some 19th century state cases. None of the cases that he could have cited provides any evidence about the original meaning of the Second Amendment, and every one of them employed interpretive techniques that the Heller Court expressly rejected. What's more, the two state cases that Scalia does cite relied on the proposition that only assassins have a reason to hide their weapons, whereas honest men carry their guns out in the open. Now, that may have been true in Georgia in 1846 and in Louisiana in 1850, which is where those cases came from, but it may not have been true throughout America when the Bill of Rights was adopted, and it is certainly not true today. Finally, the Heller Court announces that the Second Amendment does, and forgive me for the clumsy grammar here, I'm quoting the court, announces that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes, and there are a couple of examples, short-barreled shotguns and apparently machine guns as well, which are per se not protected by the Second Amendment according to the court. Well, where'd that come from? Scalia invokes a 1939 precedent in support of his conclusion, but his interpretation of the case is really completely wacky. He also invokes William Blackstone's reference to dangerous and unusual weapons, but Blackstone did not say that it was illegal to possess such weapons, and he said only that it was illegal to carry them in public when doing so would terrify the good people of the land. Maybe the court will someday provide an originalist rationale for Heller's holding that a handgun ban is unconstitutional, a rationale that Heller itself promised but did not deliver. and maybe the court will someday repudiate its unsubstantiated endorsements of some very dubious gun control laws. Meanwhile, I think Heller will stand as a monument to a peculiar kind of jurisprudence, which might charitably be called half-hearted originalism. In a narrow sense, the Constitution was vindicated in Heller because the court reached an easily defensible originalist result. But the court's reasoning is at critical points so defective and so transparently non-originalist that Heller should be seen as an embarrassment for those who joined the majority opinion. Now, as Alex and Steve described, immediately after this decision was announced, several Chicago residents filed a federal lawsuit claiming that a similar law in that city violates the 14th Amendment. The plaintiffs relied on both the Privileges or Immunities Clause and the Due Process Clause, which they maintain render the Second Amendment applicable to state and local governments. This is the McDonald case, which the Supreme Court is scheduled to decide in a few weeks. The Bill of Rights originally applied only to the federal government, and that was what was at issue in Heller. With the adoption of the 14th Amendment in 1868, the Constitution put new restrictions on the states, including the two limitations at issue in McDonald. They are as follows, and I'll read them. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. As Steve mentioned, in 1873, the court read the Privileges or Immunities Clause very narrowly, holding that it protects only those rights that owe their existence to the federal government, its national character, its constitution, or its laws. Three subsequent cases during the 19th century applied that holding to the Second Amendment. In all three cases, the court found that the right to keep and bear arms and other elements of the Bill of Rights as well pre-existed the federal Constitution. Under the 1873 interpretation of the Privileges or Immunities Clause, such pre-existing rights are not protected against state action. Shortly after the last of these three decisions, at the very end of the 19th century, the Supreme Court started taking a new approach. Rather than revisit its precedents, however, it started making some of the rights listed in the Bill of Rights, but not others, applicable to the states under the 14th Amendment's Due Process Clause. The theory underlying this process of selective incorporation is that the Due Process Clause imposes substantive limits on the government's discretion to interfere with what the court calls fundamental rights. The court has never even tried to derive this doctrine from the text or history of the Constitution. It's just something they made up out of thin air. Most of the individual rights listed in the Bill of Rights have now been incorporated through substantive due process, and a very few have been held to be insufficiently fundamental. McDonald is the first case in which the justices have agreed to consider whether the Second Amendment's right to arms is sufficiently fundamental to justify incorporating it under the doctrine of substantive due process. At the oral argument in March, the plaintiff's lawyer started out by arguing that Chicago's law violates the original meaning of the Privileges or Immunities Clause. And who do you think interrupted to ridicule the lawyer for making this argument? None other than Mr. Original Meaning himself, Antonin Scalia. Here's what he said, and I'm quoting, "Why are you asking us to overrule 150, 140 years of prior law when you can reach a result under substantive due? I mean, you know, unless you're bucking for a place on some law school faculty." That provoked some laughter in the courtroom, and Scalia soon followed up with this mocking comment, and again I'm quoting, "Well, I mean, what you argue is the darling of the professoriate for sure, but it's also contrary to 140 years of our jurisprudence. Why do you want to undertake that burden instead of just arguing substantive due process? Which, as much as I think it's wrong, even I have acquiesced in it." More laughter. Now, judging from the oral argument as a whole, I think there is no chance that the court will decide this case according to the original meaning of the 14th Amendment. But there are probably at least 5 votes for striking down Chicago's law under substantive due process. If that's what the court decides to do, the immediate effect of the decision will be to apply Heller's interpretation of the Second Amendment to the state and local governments. Because Heller approved a broad range of gun control regulations, we should not expect any massive expansion of gun rights, at least in the near term. But a great many important questions will probably still be open for resolution in future cases, and I'm going to close with 3 examples. First, Heller endorsed bans on the carrying of concealed weapons, but said nothing about a right to open carry. In other words, carrying weapons openly. Because the Second Amendment expressly protects the right to bear arms as well as the right to keep arms, the text of the Constitution, it seems to me, is simply inconsistent with allowing the government to forbid both open and concealed carry of weapons. Such a ban also seems inconsistent with Heller's emphasis on self-defense as the core of the Second Amendment right. Most people are in much more danger of encountering violent criminals outside their homes than they are within them. Second, Heller endorsed bans on carrying weapons in sensitive places, but articulated no test for identifying such locations. Unless McDonald offers further guidance, the lower courts will apparently have to develop a sensitivity jurisprudence on their own. Who knows where that will lead, but there will be a lot of questions about it. Finally, state and local jurisdictions sometimes place very onerous administrative obstacles in the path of those who desire to possess or carry firearms. Such obstructionism may become more intense in those jurisdictions that would like to impose outright gun bans that the courts will no longer uphold. The Heller 2 case is an example that shows that Washington, D.C. has already started down this road. Chicago is likely to do the same. Courts will surely face numerous challenges from citizens who claim that such administrative obstacles impermissibly burden the underlying substantive right. How the courts respond to such challenges may be the most important factor in determining whether the Supreme Court's budding recognition of the constitutional right to arms will have much practical significance in American life. To whatever degree the courts prove willing to protect our constitutional rights in this area, I think we will all owe Steve Halbrook a large debt of gratitude. Thank you.